Number 26 on the calendar, People v. Oliver Berry, also known as Chris Tucker. Good afternoon, Ms. Horowitz. Would you like some rebuttal time?
3 minutes, Your Honor, for rebuttal.
Very well.
It's Erica Horowitz from Appellate Advocates for Appellant Oliver Berry. In an effort to impermissibly bolster what was otherwise a one eyewitness ID case, the people called a man who had been arrested at the scene, knowing full well from his own attorney that he would invoke the Fifth Amendment, that he would disavow a prior statement that implicated the defendant, and he would testify that he didn't see the shooting. The people called him anyway. They called him, and from the moment he took the witness stand, they started impeaching him using every tactic imaginable.
Counsel, would there be a difference if he didn't invoke the Fifth Amendment? If he just was called to testify and told this other story? What's the difference there?
I'm sorry, I don't.
So
he wouldn't have.
He didn't invoke, because here, maybe I'm reading the record wrong, but he invokes the Fifth Amendment, right?
Yes, Your Honor.
Several times, or a number of times, and either the judge overrules the assertion and directs him to answer, or the people offer immunity. Is that right?
Yes, Your Honor, the jury is the case law is pretty settled here. You can't call a witness just to invoke the Fifth Amendment. This was a witness who had a legitimate Fifth Amendment privilege, as was known.
Right? Because some of the answers are directed by the judge.
Yes, but the judge, there was an objection to the judge probing this at all. We have to remember that nobody is in the dark here as to who this witness is and what he's going to say. This is a retrial. You have the same prosecutor. You have the same trial judge. You now have a counseled former someone who had previously been arrested and taken into custody, and he says, my understanding is that he's going to testify about what the defendant looked like, and he's going to say that this picture represents what the defendant looked like at the time.
But the harm here is that the prior statement comes in, right? That's the
well, there's more than that, Your Honor. I mean, but it starts with the Fifth Amendment, and the court
put
is
aside the Fifth Amendment for a second. They invoke the Fifth Amendment. The testimony comes in one way or another. It either is directed to answer or he gets immunity for it, right? So the complaint then is the prior statements brought in to impeach.
Well, certainly that was very powerful and improper impeachment. But the way that it starts with the people used as inferences, and they used it in summation, that the jury should consider the fact that this is a witness who's trying to hide something. He's taking the Fifth Amendment, and there's this back and forth, and until he's directed to answer, he doesn't say anything. The implication not only is trying to protect himself, but he's trying to protect his friend, because, of course, the very first thing that the prosecutor does when this witness takes a stand is go into how close their friendship is.
But isn't all that true?
What? Excuse
Isn't
me?
all that true?
That,
I mean, it's not like the DA was trying to get something out of this witness that, was a lie or that was overblown or whatever. He was not under any prosecution at all. He's invoking the Fifth Amendment as to everything except his middle name. And the judge is saying, you got to answer that question, and they're giving immunity when it's close.
Except
and all he did was tell the truth.
But in this case, Your Honor, the court has held, in Berg and other cases, you can't – I mean, he's forced to answer questions without immunity, for which he does have a Fifth Amendment privilege. Some of
Well, he
these are
didn't.
without.
That was kind of the point. I mean, you say you have a Fifth Amendment right not to incriminate yourself, not to not testify. So if they say, are you sitting in a chair, you can't say I invoke my Fifth Amendment rights not to, against discrimination. Obviously, you're sitting in a chair. So you've got to answer that question. And it seemed to me as it went through this, the judge was telling him, answer the questions that are not incriminating. The guy, I don't want to call him a recalcitrant, but for some reason he decided he wanted to do what he did. And then when he was given immunity, he testified presumably to the truth. What's the problem?
Well, they say it. No, the people insist that he did not testify to the truth. They force him to testify. They call him knowing full well, and this happened in Russ. This case is really on all fours with Russ, and in which one of the witnesses takes
I get
Fifth
that.
Amendment and is given immunity. I'm sorry.
Yeah, I get that part when you know the only reason you're calling somebody is to do that, is to say, obviously he's guilty because you can't do that. But that was not the purpose here. The purpose he wasn't in any jeopardy whatsoever. They'd already arrested him, questioned him, and found out that he wasn't the shooter.
Well, they could have charged him. There's no statute of limitations on murder, Your Honor. He was obviously, at least he had accomplice liability. I mean,
I didn't see that either.
Well, when the witness, the surviving witness says he sees them originally, they're standing 100 feet away. Then the police who hear shots see two men in the middle of the street at the car shooting. He's standing right next to the shooter, assuming he isn't the shooter. I mean, he says he's not the shooter, but the police, and then they're running together side by side.
Well, he gave a statement, though, and the police let him go.
Well, first yes, when he gives a statement implicating our client, they release him. And the DA in this case makes a lot of hay of that. Really
But even defendant's witness says that I'm sorry, no, the witness that was in the car says that it wasn't him.
Well, it says he's with the shooter, and the police arrest him anyway.
He's not the shooter.
He's not the shooter. He's
But
with the shooter, and they arrest him anyway. And they take him in handcuffs, and they hold him for a significant amount of time, and they give him his Miranda warnings, and they interrogate him, and then he implicates the defendant, and then they release him, and none of this should have come in front of the jury.
You make it sound like isn't that what they're supposed to do? I mean, somebody's dead. You know, they arrest somebody, they give him his Miranda warnings.
No, that's what they're supposed to. But, Your Honor, at this
they
trial,
let him go because he says it was the other guy. So they say, okay, you're gone, and they go pursue the other guy. Then they find the other guy, and they put him on trial.
Well, it's a long settled, they know, the people, in this case is on all fours, as I said, with Russ, in which this court held that as in Fitzpatrick, you can't call a witness knowing that he's not going to support or she's not going to support your case simply to get in an otherwise inadmissible, damaging statement.
Isn't that point not that they're going to take the fifth, it's that they're going to lie, right? Because there's a different rule. You can't call someone you know they're going to take the fifth, as I understand it, and then argue they wouldn't answer, what are they hiding? Mm-hmm. But your rule is, because that would mean anytime someone says they're going to take the fifth, then you can never call them. But what happens here is the people's argument is they lie. It's not that the fact that they take the fifth leads to these things, right? Isn't there a difference here? It's not the Fifth Amendment here that's the problem for this witness. It's that he's immunized or he's directed to answer and then he lies.
Well,
so the people would have to make the two-step jump. One, he's going to be directed to answer, or 3 steps, or we're going to immunize, and he's going to lie, and then we're going to get the statement in, right?
Well, they were different means of trying to impeach the witness. They used a whole series of things. I mean, the first was simple bias, and you're not supposed to show bias by your own witness, and defense counsel objected on those grounds. Then they move into the Fifth Amendment, and the established law in this state says you can't call him. They didn't give him immunity before, and the understanding with his lawyer was that they were going to ask some very limited questions. So people claim they acted in good faith. If they had acted in good faith, they would have asked 4 questions. They would have asked in the areas that defense counsel thought, Mr. Kervin's counsel thought they were going to ask. They would say, did you know the defendant Oliver Berry in July of 2002? Yes. Does this picture represent the way he looked at that time? Yes. Is this to show your acquaintance? Is this did you have his phone number in your address book? Yes. Is this it? And he would have been off the stand. They said those were the legitimate areas of inquiry, and they admit that that he had a privilege at least as to 4 of the 7 times he invoked. Then, even though he did not, the Court has made clear that a witness has to affirmatively damage the people's case, not simply not support it, not help the people's case, not give as good testimony as they hope, before they impeach with a prior inconsistent statement.
Let me ask you about that. There's one bit of his testimony that I think at least creates a close question on that, and that is his testimony that only one shot was fired.
Well, they called him, Your Honor, in order to be basically an identification witness. They had already called, the only witness they called had been a crime scene officer who testified there were 7 shells found at the scene. And this is a witness who clearly doesn't remember. It was really inconsequential whether or not whether he heard one shot or several. Even after he's pinned down by the prosecutor to say one, the prosecutor refers to several shots. What did you hear? What did you do when you heard the shots? And he responds. The witness himself refers to shots. It didn't affirmatively damage the people's case on who fired those shots, and that's why they called him. And they'd already established by it.
Well, but if they established who fired the shots, then doesn't it damage their case as to the charges of the attempted murder? And
Well, they had all the ballistics evidence. That wasn't really, I mean, they can't sort of try and catch a witness and tie him down on a fact.
Say regardless of whether he's had one shot, the evidence was otherwise, so it wouldn't have mattered.
It really didn't matter. They tied him down to that.
He's not quite sure what his recollection is.
It was really a pretext. It
But
was an
didn't he
inconsequential mistake.
Didn't he testify on the key question of identification? Wasn't he asked whether or not did you see the defendant fire a gun, and he said no?
He said, they started out by saying they've been told he wasn't going to say, he was going to say he didn't see the shooting. And he testifies, did you see a white car, which is what was shot at? No. Did you see the defendant shoot at a white car, which is an improper, and he says no.
Well, no, okay.
That was the question.
So he didn't see the defendant fire a gun at the car, and isn't that inconsistent with his prior statement?
Well, the first question, I mean, what he's really saying is he didn't see the shoot. He doesn't see the first question is, did you see a white car? No. Did you see the defendant shoot at a white car? No. And on cross, and they've been told, I mean, I think the DA is formulating it this way because the DA has been told he's going to say he never saw the shooting. He was told beforehand, the defense counsel said he made abundantly clear he would testify that he did not see the shooting, and under the case law here, that's considered neutral testimony.
So the correct way to do this then would be what? To do what was done maybe in Vargas, where you take the testimony ahead of time, and then the court makes the rulings on it outside the presence of the jury, and then you go forward from there. Because otherwise, it's just what Judge Garcia said, that you get to decide whether or not you can even have to come in and testify. The mere threat to use the Fifth Amendment means you don't have to testify. Yeah. That can't be the rule that we're going to – that can't be our rule.
In Russ, they asked her beforehand. She said she didn't see it, and they called her anyway. Here, a lawyer represented. He's going to say he didn't see it. He's going to disavow the statement.
Nonetheless, I think it's going to be hard for us to create a rule that says you threaten to use the Fifth Amendment, and we're not going to ask any questions.
Well, this goes far beyond the Fifth Amendment, Your Honor. They used he was ridiculed, he was released, it was used for its truth over and over. The whole implication, they had a police officer testify to say basically, yes, I released him because the police believed it, and it was used in summation that way, and there was no way, as defense counsel argued, that the jury could possibly confine it to credibility.
And I say the light is on, but
second point for
yes, of course.
You haven't addressed the expert.
Yes, I plan to.
I really would like to hear something about that, and maybe the Chief Judge will let you do it in rebuttal, but I just wanted to.
May I address it very briefly, Your Honor? Now, rather than in a rebuttal.
No.
It was clear in May of 2009 when this trial was held that courts in New York and around the country had held that the negative effect of stress on the accuracy was an accepted phenomenon, that it had a negative impact. And 2016, Massachusetts had said there's near consensus on this.
So is this an abuse of discretion? Is that what you're saying?
Yeah, the court,
And
I mean,
if it
this.
is, was it harmless?
Certainly not, Your Honor, because this Court has expressed concern about allowing such testimony to correct misconceptions about factors that lay people hold.
Well,
And here-
the expert was allowed to talk about a lot of things about
Things, yeah.
about the effect of the gun and a whole lot of things that to me sound like stress, even though that word wasn't perhaps
Used, but
used.
then-
What else would she have testified to that really didn't come into?
Well, all the evidence, I mean, this is a DA who started, this was the big issue at the first trial, that when you're under great stress, and in voir dire in this case, the DA voir dire tried to elicit the absolute misconception that stress engraves the memory on your mind, that strong emotions.
But what stress, other than the stress that was testified to about the gun and the other circumstances?
But the district attorney gets assurances from the jury before the evidence starts that strong emotion will increase accuracy. That's never corrected. It's in fact opposite, the absolute opposite of scientific studies, that it impairs.
Were those scientific studies, were they accepted at,
Yes.
You said that there was, that it was pervasively known at
Well,
that
there were
time.
5 cases that this Court has cited that have been decided before this trial. Lots and lots of cases since. They all apply to this case. The studies go way back. They're Federal cases from the 70s and 80s.
So we wouldn't need a Frye hearing, is
80s.
what you're saying?
No.
It doesn't need to go back for a Frye hearing. They need to be allowed to testify on this
Longstanding.
identification.
And the defense counsel, the defense expert, the jury never heard expert testimony about the studies that show.
Did defense counsel offer this, make a proffer of what these studies were, or what would be shown?
Well, defense counsel put it as its number one subject that he wanted the expert to testify about.
And then offer the court a basis? I mean, we're talking about all these cases and all these studies.
Defense counsel said she can, I'm sorry, Your Honor.
Yeah.
She said she can testify about all the statistics and everything about it the same way they did about the weapon focus. I mean, the people had their expert in the wings.
When did the people, at what point do the people indicate to defendants?
Oh, when the judge.
All of a sudden I have a
not
problem
until
with the
the
stress
judge,
evidence.
Not until the judge said, I won't allow it.
Before that, the understanding?
The day before, the judge, the DA said, well, the expert can't testify about something about a lineup, and they didn't like but everything else is fine, it's allowed under LeGrand. And they clearly prepared their expert to testify to that. He kept on trying to sneak stress into it. So it was the day before it says all of this is allowed under LeGrand, the other stuff, but I don't like, and objected to one thing in particular. And then the next day when the judge says, well, there's a Westchester case, the DA says, oh, yes, no good, no good.
Thank you.
I'm sorry. Thank you for the extra moment.
You're welcome.
Good afternoon, Your Honors. May it please the Court. I'm Assistant District Attorney Rona Kugler. I represent the Office of Richard A. Brown, Queens County District Attorney. The people here properly called Kevin Kervin as a witness despite his attorney's warning that Kervin intended to invoke the Fifth Amendment. As the Court stated in Amat v. United States, the prosecution, the people need not accept at face value every assertion of an intent to claim privilege.
Was there a reason you didn't grant him immunity?
There were a few reasons why the people did not give entire transactional immunity, but rather question by question. First of all, it was to avoid overly broad immunity.
What's wrong with overly broad immunity? I mean, you're not going to prosecute him. It would seem to me it would have been an easy thing to do, and then, you can ask him all the questions you want.
Well, Your Honor, before this witness came to, before we started the trial, the prosecutor had met extensively with Mr. Kervin, and his story, even at that point, was all across the board. It was in one direction, it was another. They really didn't know what was going to come in their mouth, out of his mouth when he got to testify. And based on that, it was prudent for the prosecutor to actually decide after each question, determine.
Apparently the one you thought that was accurate and truthful was the original statement. Because that's the one you kept asking about, right?
Yes, Your Honor. We had every reason to believe.
Okay, so then if you don't think he's involved, why not give him the transactional immunity? And if the witness says that's not the shooter, why aren't you granting transactional immunity?
Well, although that would have been a possibility, we're not required to do that, and it's not
I
inappropriate.
know the question is, what did you think you might still prosecute him on? Is there, let me put it another way. Is there something you still could have prosecuted him on, apart from perjury?
Oh, from perjury?
Sure.
As far as I see in the record, it doesn't look like there was anything else. Well, I mean, actually, yes, Your Honor. There actually absolutely is. Because there could have been some sort of accomplice liability that we were unaware of, and Mr. Curvin could have brought something out. We have no information about that, and I'm not saying that we did.
Well, that
but
makes
he
it
was present.
speculative, and it just, the point's made that you can't put a witness on that you know is going to invoke the Fifth Amendment. I mean, it's a constitutional right. You have a right to do it. And it just seemed to me, why this piecemeal approach that every time he says something, that to a jury would sound like you don't like, you say, okay, we'll give you immunity for that. And then he invokes again, and he invokes again. And it just seemed very troubling. For a jury to be put in that position seemed difficult to me. I just didn't know why you did it.
Well, Your Honor, the one thing that you said, though, you said that we knew. We really didn't know. It was his attorney's statement that he intended to. We really didn't know.
What I'm saying is you were just making, well, we weren't really sure, well, of course you were sure. You knew you weren't going to indict him. You knew you were going to use him as a witness. And in using him as a witness, you knew you were going to confront this. And I would have thought somebody would have said, by the way, if he invokes the Fifth Amendment, we got an issue here, And somebody decided that incremental Fifth Amendment invocations are okay.
Well, not just our office decided to confer it, but the law states that we're entitled to grant immunity as a question-by-question basis.
Didn't you also say that you were afraid that he was going to, take the blame for his friend and then nobody would get convicted?
Absolutely, Your Honor. That's exactly what the DA said at court. He could say, I did everything. Regardless of the fact that we have other evidence that would negate that, there's nothing to stop him if we give him full transactional immunity from getting up there and stating, I did it, I shot him.
The reasonableness of it is pretty slim considering the rest of the evidence, right? That's the whole point.
Right. And Your Honor, as well,
But let me go back to this question, this issue of that you said, no, we weren't sure, we just had his attorney's statement. Well, why isn't the attorney's representation good enough?
Well, Your Honor,
He's representing to you, my client informed me of the following. Why is that not good enough? We often say that we rely on the representations of counsel, and we hold clients to those representations of counsel.
because human nature, people change their mind, they change their stories, they do it all the time on the stand, as he did here, going back and forth.
Well, isn't it, I guess it was the Russ case, right, that we were talking about before? Hope springs eternal. Isn't that the theory that the judge put out there? It seems that, in my mind, it seems like the procedure that was followed here didn't make much sense, because normally you would take these questions outside the presence of the jury and then determine where immunity would be granted, and then the questions where immunity was granted, then you could do those in front of the jury, and those questions could be asked. Why wasn't that procedure followed here?
Well, Your Honor, first of all, the defense never asked for it at trial.
The people would have asked for it, I would have thought, to protect his rights, too. You would have an obligation also. It isn't just their obligation, it's your obligation, too. And that's one of the things that I find disturbing about it, and I don't want you to get down before you talk about the Frye issue, too. So let's not forget it, all right? Okay.
Okay. I also want to point out that there were many good faith reasons or basis for the prosecutor to call Mr. Curvin. So beyond the fact of his intent, there are many reasons that he was a legitimate witness and should have been called in this case, and it was necessary to call him.
Yes, but for very limited areas. I mean, that's the whole point, right? That's your adversary's point. Even she concedes that there were these areas that you could have explored, and then you should have sat down. That's her argument.
Right.
Why didn't you have to sit down?
Well, because he adds so many other first of all, as I said, we had so many reasons to believe that once he got up there and he took an oath that he would tell the truth. And he does have not...
Well, that's very hard. It's a very hard analysis for me to accept on your part, because he has an attorney making the statement that that is not what's going to happen.
But he does, Your Honor, back to your question a moment ago about what could we legitimately bring from him. There were other areas, too, not just the address book, not just his conversations with the detective, Curvin, but
Fuzzy, the name Fuzzy and so forth.
Right, and he corroborates his defendant's appearance on that date. He also adds legitimacy to the identification that we have from the surviving victim. The surviving victim, 2 years later, picks out of a lineup the defendant who's altered his appearance. And this happens to be the same person who is friends with the person that the police apprehend fleeing from the scene. So this is other very legitimate areas as well that we were entitled to go into, and it was reasonable to question him as well. Let's see. Right now, since Your Honor mentioned the Frye hearing, I guess we'll move to that at this point. And I want to start off by saying that the court properly exercised its discretion here in precluding the expert to testify, any expert testimony based on this very discrete issue of stress in this case.
Kind of a strange set of circumstances, though, where the court at first seems to say that, yes, the expert can testify as to all the issues, and then after, I think, the people rested, and then the court made a second ruling afterwards and say, well, I've researched the issue and I've changed my mind on this issue and I've gone the other way on it, and limited it. And there was, I think, a Frye hearing was requested. I don't know if one is really required now. It might have been then because we're talking 09, I guess, in the first trial. So I've never seen that sequence of circumstances where the court would deny an expert to testify at that point. It seems unusual.
Well, and the issue not is that the court denied the expert testify, but on this one.
Right, on misidentification based on stress, right.
Right. Well, I mean, there's a few factors here, and this case perhaps is a little different than your standard. First of all, the defendant failed in his burden to establish that this was generally accepted in the scientific community. He
you
never
think it's
made
generally
a formal
accepted that if somebody is under stress that it makes an indelible mark in their mind that they would never forget a face like that? Do you think that's common knowledge?
Well, Your Honor, there's two prongs to this. Number one is what was the proof that he put before the judge that this was generally accepted?
Do you think it's common knowledge that people that are under stress and see something like this would never forget a face?
Well, then I have to move to the second point. This isn't a stress case, Your Honor.
Well, the point I'm trying to make is the defendant's saying is that the DA in jury selection and everything else made a big deal out of the fact that you're going to remember a face when you're under stress. And now they want to produce somebody that says that's not true.
Well, there's also the fact that they didn't use that word stress in every different point. As one of the other justices pointed out, there were a lot of other areas that were allowed in that kind of fly around or hover around the same area of stress, like flashbulb, gun focus.
Was the people's expert allowed to testify that there is a correlation between stress and identification of witnesses?
Your Honor, I don't believe stress was an area that was permitted to go into in this trial by either side. And that's because, first of all, so going back, the court here was entitled to go on the cases and the studies that were in front of it. There were no studies. And we have to look at what the law was at that time that was in front of that judge when we're making this determination as to whether the court was correct in limiting the area that the witness was able to be questioned on. And the evidence that was in front of them, was with no cases, no statistics, no studies, just a mid-trial application for payment for a witness that didn't have any case law with it. So the court was able to rely upon what it understood as generally accepted at that time, and this was not in New York generally accepted. And the court was entitled to rely upon that. And in any event, the facts of this case established that this wasn't
Well, they say the day before, the prosecutor took a different position and put the defense in a very difficult, vulnerable situation. And then the court doesn't allow them to proceed with the Frye hearing to at least put forward to the court what you say they failed to do, because they were under the understanding that there was no problem with this expert's testimony in this particular area.
Well, there's two things with that. First of all, the record, the prosecutor doesn't go out and say, oh, yes, I think we should do this. The defense is talking about what areas they're going to go into, and the prosecutor mentions as one of the areas that they're discussing. They fill in one of the blanks, and they use the word stress. That's all that's said. It's not a full discussion on the prosecutor saying, yes, we can discuss stress here.
Did you raise an objection to any of the areas that the expert was going to cover at that point?
Some of the areas they were discussing, and without any case law, what the record shows is the next day, the court and the prosecutor...
I'm asking about the representations from the prosecution. What was your position? Did you not object to some of the areas and say, we don't want the expert to go into that area?
The prosecutor did not specifically say, I don't want that on that day, the first day that they're discussing it. But the prosecutor did discuss, they were discussing certain areas. It doesn't look like it was completely finalized at that point, so for the defense to say they were blindsided the next day, it doesn't seem genuine when these were such areas they were discussing.
Maybe I misunderstood. I thought the defense was making the argument that at jury selection and in the earlier parts of the trial, there was a big emphasis made on the fact that stress did almost the opposite. That if you're in one of these situations, ID becomes indelible, and you're more likely to remember it than not.
The prosecutor during the voir dire did mention several areas about how the identification would be affected. I don't believe that the prosecutor's voir dire emphasized stress as being an area that affected this identification.
Yeah, as was said, it wasn't, the term stress wasn't used, memorable events were used.
Being emblazoned upon someone's memory. And there's a distinction, especially when you're dealing with so many different areas that are so closely surrounding how an identification will be reliable. So that's correct, Your Honor.
But counsel may have approached it that way, but I believe your adversary's argument is, no, there's actually scientific data on this, and we wanted the opportunity for the expert to testify to this, and we weren't given that opportunity.
Well, they could have been...
You may have wanted to describe it whatever way you want, but her point is, but you're wrong, and I have an expert based on the science who's going to testify to why that's wrong. Why can't they do that?
Well, because it wasn't timely. They didn't make a motion in limine. They didn't put this in front of the court. All they did, like I said, was in that application for fees in the middle of the trial, they then say, when suddenly they think they're not going to be allowed to go into this area, that they never made an accurate and adequate offer of proof beforehand. Now they want to throw things out to the court, but they've never told the court at this point specifically what it was. They don't give that to the court, and the court at that point is entitled to rely upon what is.
LeGrand didn't already suggest that this would have been an appropriate area?
I'm sorry?
For expert testimony? There weren't prior cases already that said that?
There was nothing. At New York at that time, there was no case law that said this is generally accepted, and the court was allowed to rely upon that at that point and not have to hold a hearing. My time is up. Thank you, Your Honor.
In fact, there were 5 cases there in our, and they're cited in our brief. Brooks, Beckworth, I think Douglas is the name of one of them. They date back to the
Smith and
Drake. There were 5 cases that had been decided before then. There were no cases that said that stress wasn't accepted. In all of those cases, it was accepted. In the only case the court relied on, Banks, they said it wasn't proven in that case because the study on which the expert relied had not been introduced into evidence, but it's never been cited for the proposition that stress wasn't accepted. This defense counsel was certainly sandbagged here, and the people said on
Well, I'm surprised it's an issue. I mean, it just seems to me so often people testify that, when the accident happened, I got so excited I didn't even look to see who was driving the other car. But one of her points is that you delayed. You didn't make any application for this type of testimony until in the middle of the trial.
They asked for appointment of, and the expert is going to testify on these subjects, and the very first one is stress, and the DA says on A594, I've read the LeGrand decision, and I object to that last part, which is about people in lineups and how they react. I object to that last part. I don't believe that's something the courts have allowed. But the other 3 things he mentioned, one of which is stress, the Grand decision, I've read, the Grand decision, meaning LeGrand, and those things were permitted. And it's really only the next day, and there's nothing untimely about this, and the defense has their expert, and the prosecution has their expert, and the defense counsel says, We could have had a Fry hearing. He's not given the opportunity. He says, Judge, I'd like to show that. No, it's not accepted. We're going to deal with the things that are relevant. And this
Would
was.
there have been any prejudice to the people in holding a Fry hearing in the middle of trial? Has that never been done before?
No, it has. I've cited cases which said it's been done. This court, of course, has held that it's entirely unnecessary, and you can just have the testimony of the expert about what those studies are, and that's what happened with the other areas here. I mean, they had another expert who was disputing it and saying, I've got these studies, and she was saying, I've got those studies about weapon focus and other subjects. But really, given the facts of this case, stress was the number one issue, and he was not given the opportunity, the defense counsel, to have his expert establish that it was accepted. It had been accepted in New York. There was nothing late about this. I would just say one thing about the first point. I want to remind the court that, first of all, that the DA was absolutely intent on getting the prior statement in whatever way she could before the jury. And you get to summation, and not only is there comment using it for its truth, but it is projected up on a screen. It is read line by line. It is the emphasis that was given to it and the way in which it was described and the seeing it during the PowerPoint presentation unquestionably had the effect which was intended, that it was evidence in chief, and this was a two-person ID case.
Thank you.
Thank you.